After only about 3.5 months, the Supreme Court issued their opinion in the Trump Tariff case. The speed and the fact that the opinion was released so early in the court's term should indicate both how urgent the case was and how impactful. So we'll take a closer look next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. Glad you could join me today. I talked about this case during oral arguments, and I got into my understanding and my analysis based on the oral arguments. Now it's time for SCOTUS to weigh in. Now, you may not like the answers, but this is what SCOTUS said, and I think they pretty much got it right. Now, if you want to check my sources, of course, go to the website, constitutionstudy.com. Look at this article. All my quotes have links, so you can find the original sources and double-check my work. I'll talk more about the website and ways you can support the work that we're doing. And hey, an opportunity to get together if you'd like to. I'll do that at the end of the episode. But for now, let's talk about this case involving Trump's tariffs. Yes, this case is about presidential tariffs, but Trump used the International Emergency Economic Powers Act, or IEEPA, as justification for his claim of the power to impose tariffs. Reading from the decision, the question presented is whether the International Emergency Economic Powers Act, IEEPA, authorizes the president to impose tariffs. This legislation was created back in 1977 as a revamp of previous laws regarding allowing the president to regulate foreign commerce in an emergency. Again, from the decision, the president determined that the drug influx had created a public health crisis and that the trade deficit had led to the hollowing out of American manufacturing base and undermined critical supply chains. The president declared a national emergency as to both threats, deeming them unusual and extraordinary, and invoked his authority under IEEPA to respond. President Trump sees both the drug trade and our trade deficit as unusual and extraordinary emergency. Seeing as both have been part of American life for decades, I'm not sure unusual and extraordinary is an accurate description. Regardless, the president invoked IEEPA, but went a step further by imposing tariffs. But there's a problem with that. Article 1, Section 8 of the Constitution specifies that the Congress shall have the power to lay and collect taxes, duties, imposts, and excises. The framers recognized the unique importance of this taxing power, a power which very clearly includes the power to impose tariffs, and they gave Congress alone access to the pockets of the people. That's from Federalist 78. The framers did not vest any part of the taxing power in the executive branch. If the power to lay and collect, i.e. impose taxes, is delegated to Congress and not the executive branch, where does the president claim to get this power? The government thus concedes that the president enjoys no inherent authority to impose tariffs during peacetime. It instead relies exclusively on IEEPA to defend the challenged tariffs. It reads the words regulate and importation to effect a sweeping delegation of congressional power to set tariff policy, authorizing the president to impose tariffs of unlimited amount and duration on any product from any country. The president has no inherent authority to impose tariffs, but did Congress, through IEEPA, allow the president to do so? Not exactly. The president can regulate importation, but does that mean the imposition of taxes in the form of duties? While the court split 6-3, the justices divided the work in the writing of the opinion. The Chief Justice, joined by Justice Gorsuch and Justice Barrett, concluded in Part 2A the court has long expressed reluctance to read into ambiguous statutory text extraordinary delegation of Congress's powers. This question of ambiguous text was a serious point among the dissenters. Here, Justice Gorsuch and Barrett, along with Chief Justice Roberts, were reluctant to read into such text, especially when it comes to the delegation of congressional powers. These considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. Congressional practice confirms as much. When Congress has delegated its tariff powers, it has done so in explicit terms and subject to strict limits. Another topic of difference within the court was whether or not the power to tax is a core congressional power. I'll dig deeper into that question in the section on the Non-Delegation Doctrine. Since the power to tax is inherently congressional, the president has a hurdle he must surpass. Accordingly, the president must point to clear congressional authorization to justify his extraordinary assertion of power. He cannot. And there's the rub. There is congressional authorization for the president to regulate commerce in emergency, but where's the authorization to impose tariff? The Chief Justice delivered the opinion of the court with respect to Part 2B, concluding, IEEPA authorizes the president to investigate, block during the pending of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit importation or exportation. Absent from this lengthy list of specific powers is any mention of tariffs or duties. Had Congress intended to convey this distinct and extraordinary power to impose tariffs, it would have done so expressly, as it consistently has in other tariff statutes. IEEPA delegates a fairly lengthy list of powers to the president in an emergency, but tariffs and duties are not among them. The president claims the power to regulate importation naturally includes the power to impose tariffs. But does that phrase fill the void of the missing language? The power to regulate importation does not fill that void. The term regulate, as ordinarily used, means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or laws. That's from Black's Law Dictionary. Justices Kagan, Sotomayor, and Jackson agreed that IEEPA does not authorize the president to impose taxes, although they differ on the question of whether the major questions doctrine in legislative history. However, I do not have space to delve into those questions here. Justices Thomas and Kavanaugh published dissents to this opinion. Let's start with Justice Thomas. I join Justice Kavanaugh's principal dissent in full. As he explains, the court's decision today cannot be justified as a matter of statutory interpretation. Congress authorized the president to regulate importation. Throughout American history, the authority to regulate importation has been understood to include the authority to impose duties on imports. And just where in our history is regulate understood to include duties? Because the law Justice Thomas points to, 50 U.S.C. Section 1702A1B, states that the president can investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, exercising any right, power, or privilege with respect to or transactions involving any property in which any foreign country or a national thereof has any interest by any person or with respect to any property subject to the jurisdiction of the United States. That means there's a long list of things the president can do, but none of them include the power to tax. However, that doesn't stop Justice Thomas from claiming it does. The meaning of that phrase was beyond doubt by the time the Congress enacted the statute shortly after President Nixon's highly publicized duties on imports were upheld based on identical language. The statute that the president relied on, therefore, authorized him to impose the duties on imports at issue in these cases. Previous legislation, the Trading with Enemies Act, was what President Nixon used to justify the tariffs mentioned. Justice Thomas and Kavanaugh both claim that since a previous court's opinion did not find those tariffs unconstitutional, the word regulate was redefined to include the power to tax. And of course, no Supreme Court has ever gotten any opinion wrong, right? Dred Scott, Korematsu, Plessy v. Ferguson are just a few. Even this court recently overturned Roe v. Wade and Lemon v. Kurtzman. So I don't think that argument holds up. Just because a previous court made up a definition of word doesn't make it true or constitutional. Justice Thomas also got into the question of the Non-Delegation Doctrine, which focuses on core congressional powers. The Constitution's separation of powers forbids Congress from delegating core legislative power to the president. This principle, known as a non-delegation doctrine, is rooted in the Constitution's legislative vesting clause and due process clause, Article 1, Section 1, and Amendment 5. I understand the legislative vesting clause, but it seems that Justice Thomas is trying to limit the core legislative powers of Congress using the Fifth Amendment's due process clause, which doesn't make a lot of sense to me. Both clauses forbid Congress from delegating core legislative powers, which is the power to make substantive rules setting the conditions for deprivation of life, liberty, and property. Again, it seems Justice Thomas is trying to find a way to have his cake and eat it too. Congress delegates its legislative power every time it creates an executive agency with the power to make rules with the force of law. And since the Fifth Amendment's due process clause prohibits the deprivation of life, liberty, or property without the due process of law, how can Congress set the conditions by which the Fifth Amendment is violated. A better question is, what are the core legislative powers of Congress? Would they not be the powers vested in Congress by the Constitution? Justice Thomas goes on. Neither clause prohibits Congress from delegating other kinds of power because the Constitution assigns Congress many powers that do not implicate the non-delegation doctrine. Congress may delegate the exercise of many powers to the President. Congress has done so repeatedly since the founding with this court's blessing. Remember, the non-delegation doctrine is not part of the Constitution. It's a doctrine created in whole cloth by the courts. It appears one they only bring out when it suits their agenda. Since the court seems to have no problem with Congress delegating its lawmaking powers to executive agencies. That said, Justice Thomas does have a point. Congress has the power to both lay and collect taxes. Now, since collecting taxes is an executive function, not a legislative one, Congress passes law, one could say, delegates the power to collect taxes to the President. That is a fulfillment of the separation of powers. The power to impose duties on imports thus does not implicate either of the constitutional foundation for the non-delegation doctrine. Hence, even the strongest critics of delegation, myself included, have recognized that regulations of foreign commerce might not be subject to ordinary non-delegation limits. So long as Congress complies with other constitutional limits, it can delegate its power. Yes, Congress could pass a law that allows the President to impose duties on imports, and in fact, they have several times. But there's nothing in the language of IEEPA that delegates such power. After all, in the long list of powers Congress gave the President in IEEPA, nowhere is the power to impose taxes, tariffs, or duties. Justice Kavanaugh seemed to try to read into IEEPA something that's not in the language. The sole legal question here is whether under IEEPA, tariffs are a means to regulate importation. Statutory text, history, and precedent demonstrate that the answer is clearly yes. Like quotas and embargoes, tariffs are a traditional and common tool to regulate importation. I would beg to differ. The word regulate is defined as to control or direct according to rule, principle, or law. To claim that the statutory text shows that the power to impose tariffs was part of regulating importation just isn't true. Let's read it. That the President can investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, exercising any right, power, or privilege with respect to or transactions involving any property in which any foreign country or a national thereof has any interest by any person or with respect to any property subject to the jurisdiction of the United States. If Congress went through the effort of listing numerous ways the President could be involved in foreign commerce, you would think if they meant to include imposing tariffs, they would have said so. As for Justice Kavanaugh's claim that history shows that the power to regulate includes the power to tariff, I point to the fact that Congress has on several occasions specifically included that power to impose tariffs and duties when delegating powers to the President. So again, if Congress wanted to delegate to the President the power to impose tariffs, why didn't they say so in IEEPA? Now, in 1971, President Nixon imposed 10% tariffs on almost all foreign imports. He levied those tariffs under IEEPA's predecessor statute, the Trading with Enemies Act, which similarly authorized the President to regulate importation. The Nixon tariffs were upheld in court. And we all know the members of the courts never get anything wrong. The Nixon tariffs persuasively demonstrate that members of Congress and the public would have understood the phrase regulate importation to include tariffs when IEEPA was enacted in 1977. On the contrary, this only shows that the court understood the phrase regulate importation to include the power to tariff. Yet they show no legal or constitutional basis for such an understanding other than a prior court's baseless assertion. So what can we conclude from this decision? First of all, everyone apparently agrees that the President does not have an inherent power to impose tariffs. So the real question comes down, does IEEPA authorize the President to impose tariffs? Now, according to 6 of the justices, it does not. Held, IEEPA does not authorize the President to impose tariffs. The 3 dissenting justices claim that the power to regulate includes the power to impose tariffs, even though that language does not exist in the law. They claim that when the statute listed 9 specific things the President can do under this law, Congress just assumed regulate included the power to impose tariffs. And as proof, they point to times when the court agreed with the President that regulate included the power to tax to prove that that was Congress's intent. They also apparently completely ignored the times when Congress specifically delegated the power to impose tariffs to the president. Where does that leave the country? First off, remember that courts have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of their judgments. This is from Federalist 78. Meaning, the court can complain all it wants, but it cannot force the president to comply. Should the president ignore this decision, it could be grounds for his impeachment. Then again, there are other laws under which the president can impose tariffs, so they would be limited and take longer to be put into effect. While there may have been many foreign policy gains from the use of illegal tariffs, there's also been a lot of harm. Now, will there be a redress of these grievances? Will the Treasury refund tariffs collected under IEEPA to the importers? And what about those who paid increased costs? Will they get a refund? I guess the takeaway is that it appears the court got it right. At least the majority followed the law and the Constitution rather than the mistaken opinions of the past. Now, I know a lot of people that are very happy to see these tariffs gone, and I know a lot of people that are very disappointed that the tariffs are gone. But I look to the law and the Constitution. And yes, the Constitution does not give the president the power to tariff. It gives it to Congress in the form of duties. And Congress did not specifically delegate that power to the president under IEEPA. Since Congress did delegate that power under other laws, he has to use those. My guess is he didn't want them because they have limits on them. But that's what we'll have to deal with. I hope you enjoyed this analysis of the court case, and maybe head over to constitutionstudy.com and sign up for a mailing list, or head over to the store and purchase something. It's great to support the work that we're doing here so we can pay for all we need to keep putting out this great content. Of course, you can also support us with your cell phone with Patriot Mobile, America's only Christian conservative wireless provider. They take a portion of every dollar to support organizations that are defending your rights, including the Constitution Study. Find out more by going to patriotmobile.com/constitution. Find a plan that works for you, and know that when you pay your bill, a portion goes to organizations like the Constitution Study defending your rights. Oh, by the way, you may be eligible for a discount, and if you use the code Constitution at checkout, you'll get your new line activated absolutely free. Again, this happens by going to patriotmobile.com/constitution, finding a plan, signing up. Don't forget, use that code Constitution at checkout to get your new line activated absolutely free. I also hope you'll come join me and the rest of America Out Loud in Nashville this July 2nd through 4th to celebrate the semi-quincentennial, the 250th anniversary of the publication of the Declaration of Independence. There'll be meetings, there'll be panel discussions, and we're going to have a great fireworks display. Find out more by going to americaoutloud.news, and you'll find America Out Loud 250 right there on the homepage. I hope to see you there. I hope you come up and say hello. I'd love to shake your hand and talk about the program. Most of all, I hope you come back and join us here next time. And hey, maybe bring a friend or two when we get together for the Constitution Study.
Love the neighbors and have a few good friends.